unregulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Thank you for tuning in to another edition of Bearing Arms, Cam and Company. Cam Edwards, your host, glad to be with you once again. Hopefully you had a fantastic weekend, and we are kicking off the week with a great interview talking about a victory in federal court that happened not too long ago. A stun gun ban in Rhode Island. In fact, as you will learn, the last official outright ban on the books, struck down by a federal judge, and we are talking with one of the attorneys who was responsible for making that happen. Stephen Stamboulieh joins us on the program to talk about that case, as well as a couple of other cases that he and Second Amendment attorney Alan Beck are working on that are still making their way through the court system. In fact, one of those cases, well, it's in a holding pattern at the Supreme Court. We don't know what the court's going to do with it yet, but we're keeping our fingers crossed that the court is going to grant cert. Take a look and a listen. Stephen, thanks so much for coming on the program, sir. It's good talking with you today.
Cam, it's a pleasure. Thanks for having me on.
Absolutely. I would like our viewers and listeners to know that Stephen was originally going to join us via video, but thanks to some tech issues on my end, we're going to conduct this interview via telephone. First of all, congratulations on the victory in U.S. District Court taking on Rhode Island's stun gun ban. Although, is it fair to even call this a stun gun ban, Stephen? I mean, it sounds like the way this law was written in Rhode Island was really convoluted.
It's not a very well-written law, but it is fair to call it a stun gun ban, maybe not entirely an electric arm ban, just in the way that Rhode Island, they just flat out say, stun guns are prohibited, right? Mm-hmm. But they don't say that tasers are prohibited, right? So they considered, up until her lawsuit, they considered tasers banned. And then they made this tactical litigation decision in the middle of litigation that, wait a second, well, maybe tasers aren't actually banned and you can buy one because we consider it a firearm, which is, again, not the way you read the statute, but that was their litigation position. And what we said is, well, if that was true, and let's just pretend it is true, then people would be able to buy tasers, but that's obviously not the case.
So the judge ended up striking down this law, which I think was obviously the correct decision. Although, Stephen, I couldn't help but notice that it seemed like the judge was really unhappy about having to do so. I mean, he complained in his opinion about Clarence Thomas's judicial activism in the Heller decision. Really seemed to take some issue with Heller itself. So I guess, on the one hand, kudos to the judge for not engaging in the type of activism that he believes Clarence Thomas was engaging in, for actually looking at what the law says and saying, well, even if I don't like it, the law is what it is.
And, that's really all we can ask of a judge to do is, and that's what they're supposed to do. Even if they don't agree with the outcome, they apply the law and they apply the precedent of their circuit and they apply the precedent of the Supreme Court and they rule as to the law. And I don't fault the judge at all for ruling the way he did because he applied the precedent that was before him, and that's the logical conclusion. A categorical ban on a protected arm is unconstitutional. I just think there's nothing else to say about it.
And Stephen, is it the case that these arms are truly protected by the Second Amendment, that there's no question about it? I mean, I know you go back to like the Catano case, and this was 2016. This was the Supreme Court basically telling the Supreme Judicial Court of Massachusetts, hey, here's what we said in Heller. Look at that part about, arms coming into existence after 1791 and not being excluded from the right to keep and bear arms. Go back and reread what we said and see if you didn't come to a different conclusion here. But they have not actually come out and categorically said stun guns are protected under the Second Amendment. Is that still, though, the gist of what the Supreme Court has had to say about these things when you take everything that they've said, in toto?
Yes, and let me tell you why I think that that's the case. So the Catano opinion, if they would have said that stun guns were just not protected, like for whatever reason, there's no reason for the Supreme Court to remand, to grant cert and give some per curiam opinion, which, by the way, is a unanimous opinion. And then send it back down. They could have just simply said, whatever the Massachusetts Supreme Judicial Court said, we don't care, but stun guns aren't protected. Therefore, we don't need to go any further into the case, and we're just going to, affirm the Supreme Judicial Court, but just on other grounds, right? So the Supreme Court can basically do something like that. But instead, they realize that the Second Amendment extends prima facie to all bearable arms. Anything that constitutes a bearable arm, the Second Amendment extends to protect that arm. So, it's not fair to say that a stun gun, which most people carry, or the people that do carry them, they use them to defend themselves with, right?
Yeah.
So it's protected by the Second Amendment. And, arguments to the contrary are kind of disingenuous.
Well, let's talk about at least one of those arguments to the contrary, an argument raised by the state of Rhode Island, because they offered up arrest records, right? They was it something like 12 arrests over the past 7 years? I mean, it was a really small number of arrests, but they said, look, this is proof that these stun guns are being used illegally in Rhode Island. And
right.
What was your response to that?
Well, we got that in discovery, and I kind of chuckled when they sent it to me because, number one, they're illegal. So it doesn't matter if the person was using it to defend themselves, as Jamie Citano did in 2016, which led to the Supreme Court case, right, that merits Renee. It doesn't matter that you're using them for self-defense. They're just illegal. So, there's not an exception. Oh, okay, if your boyfriend's attacking you and you grab your stun gun, it's okay to have. It's just period illegal. So they give us these arrest records. And a lot of them happen to be, so-and-so got caught with some pot, or so-and-so was robbing someone and just happened to have a stun gun. It wasn't just that these people possessed these items, but it doesn't matter if they just possess them because it's illegal, so they would have been arrested anyway.
So what is the what is the gist of the ruling then? Obviously, the current law is struck down. Is there any wiggle room, Stephen, for the state to come back? I mean, obviously they can appeal this decision, so they can try to fight to keep this law in the books as is. But did the judge leave any leeway or wiggle room? Obviously, he said regulation is fine, right? But an outright ban is not. So, do we have any idea about what a potential stun gun? I don't want to say ban 2.0, but a new Rhode Island stun gun law might look like?
Sure. I mean, there's nothing that says that they can't regulate these items in some manner, right? They could prohibit people that mental defectives. They could prohibit minors from having them. They could prohibit people that normally the Second Amendment might not apply to, right? But you can't have just an outright ban on everyone that's not narrowly tailored or tailored at all. Like, skip the narrow tailoring. Let's just say everyone can't have one. That's obviously incorrect. Mm-hmm. But they could have some room to regulate them. As to the appeal question, I don't know what the state of Rhode Island is going to do. I mean, obviously they can appeal it, but, they are literally, Rhode Island was literally the last state to have a complete categorical ban on electric arms, period, in the entire United States.
Wow. All the rest have at least, if they still make it difficult for people to get them, they don't at least have a ban, right?
Right. So Hawaii and Rhode Island were the two states left that we went after, Alan Beck and I. Mm-hmm. And Hawaii, the judge didn't want to rule on the case and stayed it pending numerous other cases. New York Rifle 1, then Young v. Hawaii, which we're also on. And then New York Rifle 2, and then this potential legislative fix with the Hawaii stun gun ban. And that judge still has not ruled on that case. Well, Hawaii, they came in and finally, quote, repealed their ban, even though still no one can buy a taser or a stun gun in Hawaii because they've made it to where you have to have background checks. And they basically made another ban but without calling it a ban. It's like you have to jump through all of these hoops. Kind of like their permitting system for carrying a gun. We have a permitting system. We just won't ever give you a permit.
Okay, so that begs the question, might we see some follow-up litigation in the state of Hawaii in the future?
You will see some follow-up. You're going to see some follow-up litigation in the state of Hawaii in the immediate future.
Excellent. I'm really glad to hear that because, look, I mean, as you say, Hawaii's Hawaii is one of those states we've seen that really, does not take kindly to being told that what they're doing is unconstitutional, and they tend to double down, as we saw with Young versus Hawaii. And so you end up with these indefensible laws, and unfortunately, some courts, like the Ninth Circuit, that seem to go out of their way to try to find a way to defend the indefensible. And I've got to ask you, Stephen, as long as we've got you here, let's talk about Young versus Hawaii for just a second, because that is currently pending before the Supreme Court. They have not accepted cert. They have not denied cert. Is the thinking that the court is going to hold that case until after the Bruin decision comes down, and then they'll decide what to do with it then?
That's my understanding of it. So,
okay.
It feels like it's just being held. I mean, personally, I think Young is a much better case than Bruin, but Bruin came before us.
Mm-hmm.
And it just finished briefing before Young really got going in the Supreme Court, which is kind of a shame because Young is such an old case. Like, if you look back on it, the appeal was started in 2012, man.
Wow.
And like, here we are 10 years after appeal. And the Ninth Circuit stayed it pending some other case, pending Peruto. Then we briefed, when Peruto came out and said, you have no, general right to conceal carry. And then we won on the panel, which we were really excited. And then, of course, anytime that you win in the Ninth Circuit, if the county or anyone that you're fighting against doesn't go in bonk or ask the court to go in bonk, the court goes in bonk on its own. It's such a bizarre, and they just did it in McDougal, which is a different case in Hawaii on COVID. I'm sorry, not in Hawaii, in California on COVID. And the county didn't ask for the court to go en banc, and the plaintiffs won in the district court. And Van Dyke, if you read his opinion, I've never seen this happen before in a Ninth Circuit case, or in any circuit court case.
Mm-hmm.
Van Dyke wrote the majority opinion and also wrote a concurrence about how the Ninth Circuit's going to come in and bonk this case, and let me go ahead and write the opinion for you upholding this restriction.
Yep. And
he's right, and it's so sad, that he's right.
He is. I mean, look, 50 out of 50 times, I think, since Heller, the Ninth Circuit has en banc has upheld a gun control restriction, from Hawaii or California or one of the other Ninth Circuit states. They have never, in an en banc decision, found that a gun control law violated our right to keep and bear arms. Not once since 2008. And I think that really is telling. And it's, again, it's got to be so frustrating for folks like yourself, knowing, I don't want to say that the fix is in, but it must be what it feels like at this point, Stephen.
We have four Ninth Circuit cases actively on appeal right now. And then you look at something like Van Dyke's opinion, and I think he actually said it was 51 out of 51 that they no good Second Amendment jurisprudence comes out of the Ninth. It's demoralizing, but you do what you do, and then you hope the Supreme Court steps in and says, you can't keep doing this. And I think Young was one of those cases where, obviously they're holding it. I think, I hope they're holding it, pending Bruin. But, they have to come in and say, y'all can't keep doing this. If you treat this, you can't treat the Second Amendment like it doesn't exist. And you have to actually apply some scrutiny to it. You can't come in with your expectation that the Second Amendment applies to nothing, and we're just going to, blue pencil it out of the Constitution or red line it, whatever you want to call it, out of the Constitution, because it's there. And you can't stop it from being there unless you amend it. And judges, you're not amending the Constitution just with your opinion.
Absolutely. Well, again, this is why I'm glad that you are in the fight. Alan Beck is in the fight. I'm with you. I want to see the Supreme Court. I don't want them to just, remand this case back down to the Ninth Circuit with further instructions after the Bruin case comes down. The Ninth Circuit decision was so bad. I mean, it's reliance on a territorial law in Hawaii over the tradition of territorial law in Hawaii over the clear text of the Second Amendment of the Bill of Rights. That alone, I think, should cause at least 4 justices on the Supreme Court to be gnashing their teeth and say, "I want a piece of this. I want to talk about this directly." Whether or not that happens, I don't know, but I would certainly love to see it happen. And I know that, as you say, you've got a lot of cases out there percolating around the country. I'd love to have you back in the near future to talk about any other updates as they become available. But Stephen, again, thank you for everything you're doing to keep our Second Amendment rights strong.
I appreciate it, Cam. And again, thanks for having me on, and I really look forward to the next time.
Absolutely. And thanks again to Stephen for joining us on the program. I'm looking forward to having him back in the near future with hopefully some really good news to report on Young versus Hawaii, as well as some of the other cases they've got going on. In the meantime, let's turn our attention to today's armed citizen story, our good deed of the day, and our recidivist report. We will start there. Remember that story from last Thursday about a shooting on a bus in Fort Lauderdale, Florida? Yeah, well, there were no shortage of gun control advocates saying, oh, look, it's because of concealed carry. Oh, it's because of all of the relaxed gun laws in Florida. No, not so much. Turns out it was a convicted felon on probation who's been ID'd as the suspect in this bus shooting, now facing 2 counts of murder as well as a variety of other charges. And according to authorities, the suspect's criminal history dates back to 2003. When at age 15, he was charged with disrupting a school function. As a teenager, he was also arrested for robbery and grand theft. And as an adult, he has faced even more charges. The 34-year-old suspect, Jamal Myers, as I said, now facing charges of first-degree murder, attempted murder, possession of a weapon by a convicted felon. It was just, a few years ago, actually. 2019, Myers was sentenced to 3 years in jail after he was sentenced for 10 crimes that were committed between 2017 and 2019. Each of those sentences, again, 3 years long, and each of them served concurrently. So rather than being stacked one on top of one another, which would have kept Myers behind bars for, if not 30 years, more than a decade at least, he instead spent 5 months behind bars. 5 months. Sentenced to a total of 30 years in prison. Did 5 months. Because he also got a credit for more than 800 days that he had spent in jail awaiting trial. So 5 months after he was convicted, and then the 2+ years that he spent awaiting his trial, which is a problem, by the way, in and of its own right, but we'll delve into that into a future story. Myers was released on January the 8th. He was put on probation until 2025. Now, of course, he is back behind bars, being held without bond, when perhaps they should have just, stacked those sentences to begin with and kept Mr. Meyer in custody for longer than, the 5 months or so that he spent after his conviction. All right. Today's armed citizen story, Dallas County, Iowa, where a burglary suspect shot multiple times on Sunday night is out of the hospital already and is behind bars, facing a variety of other charges. As I said, this happened Sunday night just before 11 p.m., According to authorities, Dallas County officers, Perry, Iowa officers responded to reports of a shooting. They found a man with multiple gunshot wounds. He was identified as 22-year-old Hunter Kesey of Dallas Center, Iowa. Deputies said in a news release that it was, quote, quickly determined that Kesey was actively trying to break into the residence when the homeowner defended his family and fired multiple rounds. The residents are cooperating with the investigation. They made the initial 911 call. There is no relationship between Kesey and the residents of this address. There's also no danger to the public at this time. It appears to be an isolated incident. So we're glad to know that everybody in that house is going to be okay. Glad to know that Kesey has been taken into custody and is also going to recover. Hopefully this will be a life-changing lesson, and we will never, ever hear his name again over the course of this program. Finally today, our good deed of the day, in the right place at the right time. Willing and able to do the right thing. A number of drivers on Interstate 4 in the Tampa, Florida area who on Friday stopped to help a Florida Highway Patrol officer who was wrestling with a man who had attacked him. This happened broad daylight. It was about 10 o'clock Friday morning. The officer in question had stopped to check on a guy who was walking along the side of the interstate. Trooper Jonathan Ruiz saw Alexander Hernandez Delgado and stopped to make contact. Ruiz asked him for his identification, and that's when Hernandez Delgado allegedly struck Ruiz in the face, tried to flee, hitting him several more times. And that's when the Good Samaritan, first a truck driver, pulled over. Others, again, seeing what was going on, pulled off onto the shoulder of the road and helped Officer Ruiz detain the suspect there. He was taken into custody, reportedly booked on charges of battery on an officer and violently resisting law enforcement. Officer Ruiz suffered a bloody nose during the altercation, but is otherwise going to be okay. And again, that might not have been the case were it not for the quick thinking and the fast actions of those armed citizens who were in the right place at the right time and were willing and able to do the right thing. That's going to do it for this edition of Bearing Arms Cam and Company. I want to thank you for being a part of the program as always. Don't forget to check out bearingarms.com, the website, throughout the day for even more Second Amendment news and information that you need to know about. If you like what you see, you can always become a VIP subscriber. Just use the promo code GUNRIGHTS when you go to bearingarms.com/subscribe. You'll get a significant savings on your VIP membership. We're also going to say thanks by giving you exclusive news stories, analysis, content you won't find anywhere else. Again, it's our way of saying thank you for showing your support for the independent pro-Second Amendment journalism that we're doing at Bearing Arms. It does mean a lot. It does make a difference. So again, thank you very much. We'll see you back here tomorrow with another edition of Cam and Company. Until then, be well, be safe, and be free.